Welcome to the coolest place to be every Thursday at noon Eastern.
I got my own Ethicuties in the office with me today. Thank you, girls, very much. Welcome to the coolest place to be. So drop your LinkedIn URL in the chat as we get started. We got a real treat for you today. We're trying to break a new record on our emojis. We hit 5,000 last week. So let's get those emoji fingers going. I hope my daughters are not messing my office up, but that's all good. We're going to be talking about the False Claims Act in 2025, the new risks and tariffs, DEI, and beyond. We got an amazing panel. So drop that LinkedIn URL in the chat and expand your network. Your network is your net worth. Neither are big enough. And you got to connect with at least 10 or 20 people today. Absolutely follow the folks that are on our panel today. Follow me, follow the Ethico channel. That's where you can get some great clips every single week. I'm going to run through some announcements. Of course, if this is your first time joining, you're going to get a bunch of free CEUs. Every single week, we're giving out CEUs nonstop. So this is the place to come for free credits and to expand your learning. And speaking of expanding your learning, we have so much thought leadership going out there. You got to be reading all the time. Readers are leaders, as my mom said. And boy, was she right. And speaking of my mom, she loves our podcast, and I think you will too. The Ethics Experts is our podcast that, top 2% global podcast. So round of applause to the Ethico team. We constantly get great people on who share their perspective, who share their background. So if you have not checked out an episode, now is the time. I'm going to be dropping into the chat a Rate Your Podcast link. And so if you love the show or you don't love the show, but you love, ethics, if you're an ethical person, you should rate this podcast. Give us 5 stars. It does a lot to promote the podcast and get business ethics in people's playlists. So go ahead and hit that now. 5 stars would be phenomenal. Also want to share a little clip from our recent episode with Michael. This guy is brilliant.
For a couple of years, myself and one other former recovering lawyer, a former prosecutor, were just pounding the pavement, knocking on doors, having meetings with general counsels to say, let's talk about your compliance program. And the response we usually got was, or what? And so
wow, that's so cool.
Talk to them about what a compliance program was, how they can build it. It was less about culture as it was, what risks do you have? How can you train employees to avoid those risks? And so was fortunate that I think the marketplace became ripe with the scandals. We were at a good time, at a good place. And we're able to develop a pretty large client base within a short period of time, such that Integrity Interactive needed to create an advisory services function that was more formal. And so I moved over out of business development and started doing that kind of consulting work with clients.
So I was wrong. That was with Matt. He was with Integrity Interactive, which was the first compliance learning company that later got acquired by SAI. So that episode is packed with a ton of phenomenal stories. And speaking of ton of phenomenal stories, last week we had the one and only Christian Hunt on, and we gave away a bunch of his books, Humanizing Rules. So if you have not bought this book yet, shoot over to Amazon. Or save yourself the waiting time, save yourself the shipping fees. Well, hopefully you're a Prime member. We are not endorsed by Amazon, by the way. But Humanizing Rules is a phenomenal book. It should be living in your bookcase or on your nightstand. And we, of course, are going to be giving away 5 of those today. So we're talking about a really cool topic, something that is changing. We're going to be diving deep on it. So keep those questions coming, and we will, of course, work them into the conversation. So 5 of these we're giving away. I mentioned this maybe a few weeks ago or maybe a month ago, but our job is to crowdsource risk intelligence, right? We need people to engage in this risk management apparatus that we are over. That's the job of ethics and compliance. We have all of these human beings in the organization that can be participants in our attempt to manage risk and mitigate risk in the organization and drive more business excellence through our organization. Over the last few months, we had over 50,000 responses. This is what 50,000 people look like. We had 50,000 responses on our intake. People can rate their experience at the end, and the average was 9 out of 10 stars. So the reason that that's important is that when we can show up to these human beings who were putting posters up and trying to influence to raise their hand and speak up when they see something wrong, when we can engage with them like human beings and give them a good experience, that starts to spread throughout the organization. There are orders of magnitude more pieces of risk intelligence in your organization than you're probably getting. And so when you can have an experience or you can provide an experience to those folks that corresponds to what your heart is, and we can be a true extension of your team, it really helps you do your job a lot better, have a lot more impact, and sleep well at night knowing that your program is getting more effective. So Ethico, round of applause. Best ethics and compliance software in the world, as per G2. We're the momentum leader and so forth. And while our Promised Land promotion did end last week, we got a new promotion going for July. Yes, we're in July now. So another look there. For July, we're going to be giving away 50% off of our risk assessment tool. So this is our new tool that we launched. Thank you all who contributed ideas on how this tool can really be impactful and how it can help move our profession forward. So up to 50, or not up to, actually 50% off if you book a demo during July. So if you're interested in that, seeing how you can load your entire risk assessment process into it, or leverage it, how some of these forward-thinking clients that we're dealing with are leveraging it with bite-sized risk assessments around particular, topics like AI or like discrimination and harassment or something like that. This can really do a lot to direct your efforts. Remember, Parkinson's law means the work fills the available time. So thus, our job is really about making a bunch of bets with our time and our limited resources. And so the more insights we can have on how we can direct those bets, the higher the expected value of the time that we spend, and thus the more effective our program and so forth. Coming up in a couple of weeks, it's happening again. Remember last year, wild success, Ethicsverse Day. Look at this. We got 4 sessions this year. We added another session. Look at all these geniuses coming on here. Of course, the one and only Matt Kelly is going to be there moderating several of our panels. But let me give you a little video. Okay, this is hot off the presses.
On July 24th, the one-day learning event of the summer is returning to a computer screen near you. Ethicsverse Day is back and better than ever. An all-day virtual event packed with guidance from leaders in the ethics and compliance space. 4 epic sessions over 12 CEUs and insights from industry leaders such as, for Session 1, Tom Tipper X. Harden, Ellen Coons, and Mary Inman. For Session 2, Matt Kelly, Andrew McBride, and Reed Blackman. For Session 3, Leah Simonton, Scott Hogan, and Matt Axelrod. And this year, we've included a bonus session with Hema Lomax. Don't miss out on the grand return of this prestigious event. July 24th. Register now at ethico.com.
July 24th. How do you like that voice? July 24th, it's happening. So come to Ethicsverse Day. We're going to be giving away a bunch of great prizes and everything else. Okay, before we get started here, I got to always call out my favorite blog, especially when Matt Kelly is on, Radical Compliance. So if you want us, none of us have a crystal ball unless we're coming to Radical Compliance. So if you are not signed up for the newsletter, if this is not your homepage, you need to step your game up a little bit. Every article that comes out there is so insightful, and you get a lot of great insights. And he does that job thing every single week where he tells you what jobs are out there. So really glad to have you here, Matt. I'm going to pass it on over to you. And look at that. We're up to 2,000. That's a new record, 2,000 on the intro. That's looking pretty good. I got a good feeling about today. Over to you, Matt.
All right. Well, thank you very much, Nick, for the kind words. I appreciate that intro. That's pretty nuts video for Ethicsverse Day coming up. But for the listeners here today, thank you for joining us. Like Nick said at the start, we are here today to talk about the False Claims Act and enforcement of it. I suspect most of our listeners already know what the False Claims Act is, but in short, it is a law, I think, originally passed in the Lincoln administration. And if I'm wrong and anybody wants to call me out on that, please do. But it is one of the oldest laws in the books for government contractors that prohibits you from submitting an inflated claim, basically an anti-fraud statute. So you are on a contract for $100, you only do $80 worth of service, and so that is a false claim, and that is the government's primary anti-fraud tool for government spending, government contractors, Medicare fraud. And lately, this is what we're going to talk about a bit today, is this expanded scope of False Claims Act enforcement the Trump administration wants to try to impose around illegal DEI programs, around tariff avoidance, around cybersecurity. If you're a government contractor certifying you have achieved some cyber standard, which you have not. It is a very expansive view of the False Claims Act. And we still have enforcement of the False Claims Act like we've seen for the last 160 years. Just yesterday, the Justice Department and Health and Human Services announced a task force for enhanced attention to healthcare fraud, which is squarely within the False Claims Act. So we have an awful lot to cover there. We have two other great speakers in addition to Nick. First is Lisa Dykstra, and Lisa is a partner at Morgan Lewis and has worked with corporate compliance for years on False Claims Act issues and litigation. Lisa, thank you for joining us today.
You're welcome. Good to be here.
And also joining us, sort of on the other side of that equation, is Ari Yampolsky. Ari is a partner with Whistleblower Law Partners, representing whistleblowers, because the False Claims Act allows whistleblowers to file a lawsuit on behalf of the government about your alleged fraud, and then sometimes the department joins the case, sometimes they do not. But whistleblowing and anti-retaliation protections are also very much woven into False Claims Act litigation. We can talk about what are the good compliance programs you would need to have around documentation, around listening to whistleblowers, investigations, and whatnot. I'm also curious if this expanded enforcement scope is really going to go very far in court. Nobody's tried it before. I don't know. So we have a lot to go on here. Ari, thank you for joining us as well. We're glad to have you here.
Thank you so much.
And everybody should know Ari is dialing in from vacation. That is dedication to the job. Thank you, Ari. We appreciate that.
Dedication indeed. My gosh.
So I guess, I wanted to ask Lisa and Ari, both of you first, sort of a table setting question about what are we supposed to make of the Justice Department's desire for this expanded use of False Claims Act enforcement. I have used the metaphor that it looks like a Swiss Army knife of enforcement now, that they could try any sort of offense. If you're a government contractor, you might wind up facing the False Claims Act. I don't know if that's the right metaphor. There's still the hammer of plain old False Claims Act enforcement like we've seen for many years, which is big and significant. But Lisa, let me ask you first, and then Ari, and then Nick. Like, what do you think of this? What are we supposed to make of this announcement?
So thanks for the question. I think the new focus, at least as you said, the False Claims Act has always been used to address all sorts of fraud and abuse throughout the industry. Anybody contracting with the government, submitting false claims that are either factually false or legally false, either giving the government something that they didn't ask for, not giving them what they did ask for, or certifying that you complied with regulations that are material to their purchase that you did not comply with. The focus now, I think, that is really, really new is the focus on the DEI, quote unquote, illegal DEI. So I think, as we all know, in the early years of the Trump administration, President Trump passed a number of very significant executive orders relating to DEI. And I will note that the executive orders are not law. They set forth his policies, and they can be interpreted by the courts and then assessed, and whether what he believes is illegal DEI is one thing and what the courts view it as is different. But in his executive order 14173, he specifically set out a emphasis to end illegal discrimination and restore merit-based opportunities. So interpreting that executive order, the courts, his Justice Department has now put together a number of memoranda and a number of initiatives, basically to, number one, require government contractors to certify that they do not operate any programs promoting DEI that would violate any federal anti-discrimination laws. And then the government contractors also have to certify that they comply with the anti-discrimination laws and that certification is material to the government's decision to pay. So those are things that are going to be added to government contracts. They have been added right now. There's a lot of procurement officers out there from different agencies adding those to the contracts in different areas. The languages differ from contract to contract, from agency to agency, but the procurement offices are adding that language to contracts to make it easier for the government to then prosecute or pursue litigation against any company that they view as having policies that violate the civil rights laws. So that's the biggest new area, I think, that we've seen. How the courts are going to interpret that and the different elements of the False Claims Act will yet to be seen.
Okay. And Ari, give me your take too, because I know you've already written about how you're skeptical that the DEI angle might go very far in court. I don't know if you have thoughts also about some of the other angles, such as tariff collection or tariff evasion, or I know that they have enforced on cybersecurity and claimed that if you certify, but in fact you didn't achieve a cyber standard of some importance, that could also be false claims. Like, I don't know what I'm supposed to make of this. And is my Swiss Army metaphor correct, Ari, do you think?
I think it is. And you're right that I am duly skeptical of the most recent announcements by the Department of Justice in terms of going after federal contractors for illegal DEI. Lisa and I probably disagree about lots of issues related to the False Claims Act. My guess is that we're going to be pretty squarely in line on a lot of this. And I do want to separate out the DEI focus from Matt, what you just described, tariffs, cybersecurity, which I think are, particularly in the case of cyber, a little bit more novel, but much more squarely in the heartland in terms of what has long been requirements that have long been in federal contracts that involve cybersecurity needs. To flip to the DEI focus and your metaphor, the False Claims Act is a very, very powerful tool. But I talk to potential would-be whistleblowers all the time in terms of saying that it's really powerful, but it's not limitless. And it was designed to address knowing deception that causes the government to pay when it should not have. And the idea of turning it into a Swiss Army knife to go after DEI policies or other politically controversial programs raises some real concerns because not every policy disagreement or compliance issue is fraud. And courts know the difference and police that difference every day. And I think we'll probably get into it a little bit more, but the False Claims Act, like any other law that creates liability, has certain elements. And falsity, knowledge, and materiality are three that are huge hurdles for the kind of novel legal theories that the current Department of Justice leadership has been spinning up.
All right.
In terms of, it was said that some of the other focal points have long been sort of part of the core of False Claims Act enforcement. The Trump administration is obviously focused on tariff and trade-related violations. Customs-related, duty-related violations, evasion, have been part of False Claims Act enforcement for decades. And when importers, for example, engage in various kinds of schemes to underreport and underpay the duties that they owe, that is a violation of the False Claims Act. There is very, very little doubt about that. And in fact, there was a recent decision last week out of the Ninth Circuit that sort of further cemented and confirmed the False Claims Act as a tool the government has available to it to enforce duty evasion.
Okay.
So, yeah.
So, for example, I'll stick with cybersecurity and materiality for a moment. It does seem to me if you are a government contractor selling missile defense systems, you want those things to be secure. You need to have those ducks lined up in a row. And if you didn't, now that you've framed it that way, I don't see that as a very far stretch that this missile defense company might wind up at the wrong end of the False Claims Act, because cyber and defense are pretty much entwined at this point. Is that the right way to think of it?
Yeah, I mean, I to my mind, it is, and I think that you're using that example to try to tether the requirement to the industry, to sort of amplify why it is important in the context of missile defense, as an example. But there are many other contexts in which cyber requirements are also important, and those range from other kinds of government contractors in non-defense settings, in research institutions, to healthcare settings. And the common thread among those is that the cybersecurity requirements are plain and they're plain legal requirements. And there are certifications that contractors make of their compliance with those requirements. And so, one of the big challenges on the DEI side is these are new requirements. We don't know what illegal DEI is. Lisa said a moment ago that there are procurement officers who are now promulgating, new provisions for contracts for federal contractors, but that wasn't the case 3 months ago, a year ago, 10 years ago.
Which then kind of leads. Oh, go ahead. Go ahead, Lisa.
I was going to say, on that point, I agree that when the issue that you're certifying compliance with, like cybersecurity, is tied to the substance of the contract, that's where you have your normal false claims type cases, where you have like, I certify in the healthcare area that I comply with the FDA rules and regulations, and I comply with the Food, Drug, Cosmetic Act regulations, and you're a healthcare company. Those are tied together substantively, and they form the core False Claims Act cases. Similarly, if you are in a contract with the government where you're protecting highly classified information or highly HIPAA protected information, and you certify you comply with cybersecurity, those are kind of the core typical issues where the government would in fact rely on a certification of cybersecurity compliance in a contract where there's sensitive information. I agree, the DEI issue is a new kind of, they're trying to say that everybody who has a contract with the government, no matter what it relates to, should also comply with illegal DEI. Or comply that they don't have illegal DEI. To say that whether you comply with illegal DEI and the civil rights laws is really material to a contract across the board, substantively dealing with anything, that's where I think the stretch is going to come when the courts have to deal with these issues.
Did you steal my notes or something? Because that's exactly what I was going to say. Okay. Like, is it actually material? Is civil rights compliance truly material to every single contract? I think, to your point, that's really where the challenge is going to lie. And that's, kind of arguably the over application of this, of this act to kind of, steer the ship in a different direction.
Right, which is why they're trying to put the certification in that you certify that it is in fact, you're like conceding it's material. But recall it, the Supreme Court's decision, Escobar, it doesn't necessarily matter what the contract says in some regard. It could say it's material, it could not say it's material. The court is going to do its own evaluation of whether the term and compliance with the specific regulation is in fact material to the decision to pay. So it's yet to be seen.
One question on my mind for all the listeners here, they're probably thinking, okay, in this world, regardless of how far the DEI may or may not get in court, that issue, what do I need to get good at for my compliance program? And it sounds to me like it is partly a documentation and paperwork challenge, frankly. But I'm also wondering, how often does it come about that the executives at the top are signing something to say, well, yeah, of course, we have this lined up in a row. We don't have illegal DEI. We do have strong cyber. But there are employees further down saying, well, obviously, we all know down here on the ground that's not true. And there's this disconnect. So I'm thinking, do they have to get good at paperwork? Do they have to get good at understanding what we're certifying is actually true? Is it often the case that up and down chain breaks? I don't know, maybe Lisa, I'll start with you. Like, what do you think about that? Or what would you say to people that you need to get good at this thing, this new world? Yeah. What would you say? And then Ari, what would you say?
I think that it crosses the board from, as you said, compliance with general regulations that are applicable to your industry, Food, Drug, and Cosmetic Act, et cetera, or DEI, applies to both, that you should have the appropriate audit conducted, right? In the DEI situation, we're given the example to a number of clients are coming forward and saying, what do I do in this situation? How do I, to your point, document and make a record of what I'm seeing? So if you do a privileged audit in any industry, privileged audit here for DEI and your compliance with the civil rights laws, that privilege audit can assess your policies and procedures, review them, make sure they're documented carefully, they're carefully articulated, and comply with the law as the legal team believes it to be at this point in time. And again, that can change. then we recommend that somebody from compliance or somebody from the business separately take that advice from the legal privilege advice, look at their policies and procedures, and document at any point in time that they have a good faith belief based on their own business judgment that their company is in compliance with those laws, for example, the DEI laws. Mm-hmm. And then make sure that whoever's signing contracts with the government is having some level of communication with that person so they understand where they're making their certifications. And then that good faith compliance determination that you are complying, that good faith belief of compliance with the law can be a very strong defense to the False Claims Act. And then we also suggest that you do it in a circular manner. Once you make that good faith determination, you document it, you then train on it, and then you again monitor and audit again. So you kind of continue that wheel so that you're always in some way having some refresh review of your policies and procedures.
Okay. And then Ari, same question to you, although maybe from a slightly different whistleblower perspective. Like, what do you see companies, where are the breakdowns that you see and you wind up involved in some sort of litigation or whistleblower?
Yeah. So there's
like Lisa dropped off.
There she's back. So to echo again, what Lisa was saying as a starting point, internal legal analyses that show compliance, document compliance with civil rights laws, records of voluntary disclosures made to agencies, a well-documented policy process. All of these kinds of things can show that a company acts in good faith, was transparent, and didn't have an intent to mislead. That's really key. But getting to where sort of Lisa ended, checklists help a lot, but they don't save a company unless they are backed by a kind of genuine culture of compliance. Mm-hmm. What I see when folks come to me to assess a potential whistleblower claim and coming forward with potential violations is generally not, I've identified something and have never talked to anybody in my company about it. It is almost always the fact pattern is an individual has identified an issue or a set of issues, raised them internally, gone up the chain and through the compliance protocols to the extent that they exist in the company, and found no relief. And so it's less of an issue, I think. By the time it comes to me, it is very, very rarely an issue of, an executive signing some sort of certification of compliance and having no idea what's going on down below. Okay. It's a situation where you have more concrete knowledge that helps to sort of make out the intentional aspect of the violation. The False Claims Act is not for the oopsie accidents. It is when you have intentional violations of legal requirements that are material to the contract.
Okay. Yeah, I completely agree with Aaron on that point, that the whistleblowers that I have dealt with on the defense side, they are people who have raised legitimate concerns, and usually through the legitimate channels that the company's already set up. Like, they have filed whistleblower complaints internally, or they've gone to HR, or they've gone to senior management, and the senior management hasn't done what they view as an effective internal investigation. And so a lot of the times when we have internal issues, we try and do thorough investigations with our clients, make sure they're documented, make sure the communication to the complaining parties is as best as possible, disseminated, understood, addressed, because I agree that many whistleblowers will go internal first and don't really have any intention of going to the government. They want to speak and they want to see relief within their company.
Yeah, this is not like a cash grab for guys. They're really trying to get it fixed. And like Ari said, they're hitting some wall and they're not getting that relief. And Sherry has a question. Well, this is actually more of a comment. She said, thanks for this, Sherry. It's so crazy to hear that it even goes through compliance and nothing was done about it. It's baffling. So do you have any perspective on that in cases that you've been involved with where like, does compliance just not have teeth? Because usually, I mean, in my experience, there's really well-intending people in compliance. They're not like trying to brush stuff under the rug. So like, where does that breakdown actually happen? If they're like trying to go down those existing channels, as you said.
I personally feel like, and I think Ari mentioned this too, is there has to be a culture of compliance and it has to come from leadership. And so the senior management has to convey, and this is what the government looks at, the DOJ looks at this all the time to say, well, what was the culture of the company? What was senior leadership doing? Did they stick their head in the sand? Did they not care? Did they give compliance the resources they need to actually be an effective program? So I think that in my mind, it is up to the senior management, the boards, to make sure that their compliance department is effectively financed and resourced. And that is what the DOJ looks at, to see whether or not there's an effective program in place when they're assessing whether to pursue a case and whether there's knowledge and intent behind whatever alleged falsehood there is.
Ari, what would you say?
Yeah, I mean, you're finding a remarkable amount of agreement here.
I thought this was going to be a Royal Rumble. I mean, I don't know what's happening.
I mean, well, I think we may have reached the limits of the False Claims Act. What I was going to say on this point is that, you know, I think that the reality is that employees become whistleblowers when they feel ignored or retaliated against. And so what that means is that recognition, follow-up, transparency about internal investigations and the process go really, really far. And to put it starkly, they go further than money does. Most whistleblowers don't come forward for the payout. They come forward because nobody has listened to them. And so back to, you know, your point, Nick, mishandled investigations are really often the tipping point. And why they're mishandled from a whistleblower's perspective, I think that there are, you know, as many answers to that, potential answers to that, as there are, you know, species of animals in the world. There are lots of reasons that it can happen, but that's really the core of it. So, you know, from my perspective, documenting the process, communicating progress where it's possible, and avoiding knee-jerk retaliation are really kind of touchstones that keep would-be whistleblowers from coming to people like me.
You know, so I think there was a lot of great responses. Let me just say this real quick, Matt. I think in both of those answers, there's a lot that we as compliance pros can take from that. So I think even if you're an organization that's not as upstanding as you like, or you don't have that tone from the top that you would like, there's still agency that we can exhibit in the investigation process to, you know, extinguish the perceived injustice of not being listened to, or, you know, the high potential of someone, you know, feeling retaliated against. Whether it happened or not is irrelevant. Retaliation kind of lives in the eye of the beholder. So those are things that we as compliance can touch directly. On the other side of it, you know, I'm always looking for, like, you know, you guys know I love that game Risk. You got to get more land. Nobody on this call has the number of, the amount of resources that they would like. And so that becomes a game of influence. How can I frame out my program inside my organization to get that endorsement from that tone at the top, or get that endorsement from the CFO perspective to, you know, loosen those purse strings so that we can get some more. So we got to use it all. We got to use everything. And as you know, in the context of this conversation, the expansion of the False Claims Act presents a threat to organizations, because there's an increased potential for, you know, more of these claims to be brought forward, which, you know, 70+% from my research are coming from whistleblowers. So if we don't have the resources we need, we should be using this as a canary in the coal mine, so to speak, to kind of open that conversation to get some more. So I think we can leverage this internally to get more. And we should note what both Ari and Lisa said, that if something is going to end up tipping into a whistleblower complaint, most of them are whistleblower complaints, there's stuff we can do to help kind of prevent that by being transparent in that process.
One question I want to pull on a bit more is how you do communicate to the internal reporter that, you know, the investigation has been ongoing. Maybe there are some things you can tell, maybe you can't. But Lisa, you had used the phrase, that they turn whistleblower when they don't see, what they view as an effective investigation. And I have to think that, what whistleblowers tend to view as an effective investigation is kind of sort of that they're right. And if the company says, no, this is unsubstantiated, they're going to say, I disagree with that. And I'm going to go to report this on a whistleblower hotline. There was somebody in the chat who said that they had gone through that. They investigated a whistleblower's claim internally. It was unsubstantiated. The whistleblower didn't believe them, went to the regulators. They investigated. They found it unsubstantiated. But I mean, there's a tension there that has to be resolved. So I'm trying to think through what is the proper love and care of an internal reporter to make sure that they don't go wild-eyed crazy and complain to a regulator when maybe that's not the right thing. Maybe they are just legitimately misunderstanding. Is that a real issue that happens here? Lisa, what do you think? And then Ari.
Yeah, absolutely. I think I would put it in two buckets. One, where you have a whistleblower who's making a complaint, and while they think it's some policy or procedure or law is being violated, they may not have a full understanding of the process, and you determine they're wrong. Or there's a situation where you determine they're right? So there's two different kinds. I've had cases where whistleblower comes forward and he is good at heart, but he believes what he believes and is dead set on his understanding and interpretation. And we do an internal investigation and we engage with him. And there have been times where we've sat down with whistleblower and explained exactly our findings in a privileged context, but we said, explain why we feel the allegations are not meritorious and why we've done a thorough investigation. And I've sat in meetings where the whistleblower will say, yeah, I understand. You're right. I get it. And then 2 seconds later, they are back exactly where they started. Now, in that situation, the best you can do is really make the effort, because some whistleblowers will really appreciate the effort that you've made. Document the investigation, document your conclusions. If you can, put together a non-privileged memo to the file so that you can have something that you can share if the government does come. In this particular case, I'm thinking of the whistleblower did go to DOJ. DOJ did come to us, and we were able to say immediately, we know, we've done a full investigation of this without waiving privilege. We can tell you we did a thorough investigation. Here were our conclusions, and we shut down their investigation. And that was extremely effective because we had all of the facts and at our fingertips. In the other situation where the whistleblower may have stumbled onto something that is a problem, I think in those situations, you have to be as candid as you can without waiving privilege, again, in some circumstances, and then decide how you're going to actually address it. And if there's something that you can then address, change your policies, do more training, in that way, the whistleblower will feel, in some situations at least, that they have been heard, that there are real changes being made, and it's kind of, to some extent, the new training and policies you're implementing to address his concerns or her concerns are public in some way, not his complaint, but the compliance measures you take are presented in a way that's public and receive the appropriate attention. Okay.
Ari, do you have any thoughts along these lines too?
Yeah, I mean, look, you can't have a 100% guarantee against, people who are going to be so committed to their perspective, irrespective of the facts that they learn. Mm-hmm. That's just always going to be a feature of one's life. People deal with that in their families, they deal with that in their workplace. But as a practical matter, when employees who have set on something come to, sort of specialized whistleblower counsel, like my colleagues and I, like others, in our bar, they are generally coming not because they believe that they have a disagreement with the company's perspective on a given issue, but it is because they have been treated dismissively or with lack of professionalism. And Lisa says that, within the sort of practical bounds of privilege, being able to share what the company's findings are, the documentation sort of defensively for the company, if there were to be a DOJ investigation at some point, and the effectiveness of that. I mean, those are all very, very good and important tips and practices. But the truth of the matter is that when a whistleblower comes forward to me with what I view as a strong claim, you know, in the vast majority of instances, those aspects are not going to be there. You know, that investigation may not have been done, or the individual was not provided any explanation whatsoever. So it's a little bit of the two extremes that we're working with, and so, you know, to the extent possible that from the company perspective that you can follow Lisa's advice, it's good, it's strong, you should do it.
I mean, that's super empowering. I mean, at the end of the day, this is a people business. And if these claims are coming from people, I mean, how many times, you know, watch the replay and click a button every time somebody said the word feel? Like, these actions are a function of these feelings that folks have. And Ari just said, usually when somebody comes to me, it's because they were met with a stiff arm and they weren't dealt with professionally. And I think, you know, back to that concept of, like, you know, putting our heart into it, or like putting a good faith attempt to try to share whatever we can, you know, in a responsible way. I think that can do a lot to influence that person to make them feel heard. I mean, we can't control if a whistleblower is irrational. But I would think the best bet is to assume that a very small proportion of whistleblowers are irrational. I would assume, you know, most people are rational. And if we can show up in a professional way and be transparent and make them feel heard, you can probably do a lot to curtail kind of spurious, you know, whistleblower claims, you know, in this vein.
You know, it's striking to me as I'm listening to all three of you. This is really about how do you keep the internal reporter on the company's side, for lack of a better word. And if the company does give them the stiff arm, it's like, well, he's not on my side. Now I'm going to go and report to a regulator. But I can remember at one point there was a craze of people asking questions 10 years ago or so, like, should we have our own internal whistleblower awards program? And I was always thinking, you're never going to afford that. The federal government will always be able to afford more money in a whistleblower program. So it is much more about demonstrating a thoughtful attitude, a listening attitude, handling investigations appropriately, documenting everything well, but trying to keep them on your side, because the whistleblower route exists in tension with that. And, you know, then it's more adversarial. I did want to ask some questions just about the mechanics of False Claims Act lawsuits. I don't know how many of our listeners, their companies have been involved in these, but maybe Lisa first. You know, I guess my question would be, how long do these take? Because I often write about FCPA claims, and it seems like the misconduct was 12 years ago, 10 years ago, a zillion years ago, and it takes forever to litigate. But how does it change when the Justice Department joins in as a co-plaintiff? Does the company think, okay, game over, I want to settle and end this? Like, how does that work? So
the whistleblower, if it's started by a whistleblower, because the DOJ can certainly start their own False Claims Act investigation, but if the whistleblower files a complaint, they file it under seal, they file a statement of facts with that complaint, a disclosure statement, that goes under seal. It's under seal for a mandatory period of 60 days while the government has the right to investigate, the obligation to investigate. So to the DEI issue, I don't know how many complaints are right now filed under seal by injured parties, quote unquote injured parties, or people who have political agendas that may be under seal and are being reviewed by the government. Those complaints generally will then, if the government feels that there's something valid in the complaint, they want to pursue it, they will issue a subpoena to the company. That subpoena then can take years to resolve. And in the ordinary circumstances, the court, at the government's request, will continue to keep that complaint under seal while that investigation goes forward. That investigation can take a year. I've seen investigations take 6 years, and they can last, and they are extremely expensive. Whether you're right or wrong at the end of the day, they are extremely expensive investigations. If the government decides not to intervene and not to pursue the case, they'll file a notice of declination, and then the Relators Council, of course, can then pursue that case. And I've had those cases last 10 years with appeals to the Third Circuit. I mean, there can be massive litigation depending on the size of what's at stake. If the government intervenes, then the Relators Council, in my experience, is like, great, I can sit back, the government will take this over, they'll do the work, and the government will litigate what they feel is the most significant harm. And again, those cases can take a year. I've never seen them take less than 3. They can take 10 years to resolve. At the end of that case, they almost always resolve by a settlement unless there's a summary judgment dismissal. And then the relator will also get paid at that point in time. We have had cases where we've gone where the company, there's a case that's public involving a vaccine where the company was not going to settle. They knew their vaccine was 100% effective. It was tested properly. The Whistleblowers Council wanted to pursue the case. The government had declined. That case went on for, I would say, 8 years before the court granted a summary judgment motion for the company across the board, which was appealed, and then they won again. So they can take extremely long time.
All right. Ari, what's your take on the duration of these cases, and how does it change when the Justice Department comes in on the side of the relator?
Yeah. So just to put some number bands on it from kind of my perspective, I think about these cases from filing to resolution taking an average of 3 to 5 years. And that is kind of when the, yes. I'm thinking of when the government intervenes in those cases, and that's an average. It could take, like Lisa said, significantly longer. My firm is currently litigating a case alongside the Department of Justice that was filed in 2011. That's not a crazy outlier. So, they can take a very, very, very long time. Also, as Lisa said, the decision by the Department of Justice to intervene in the case is the turning point, is what, the inflection point in any matter that is brought forward by a relator. Those cases, I believe, statistically settle over 90% of the time. When the Department of Justice intervenes, it is a small minority of cases where the Department of Justice intervenes that defendants continue to litigate them. That is often, I think, a function both of the evidence that the Department of Justice has been able to develop over the course of the investigation. The Department of Justice has what's called civil investigative demand authority, where basically they can subpoena records, sit individuals down for testimony, and all of that is sort of within the secret sealed process before they need to have any kind of public filing. So it's a very, very powerful investigative tool that allows DOJ to build a case before they bring it to anyone, which is a large part of the reason why these cases settle as often as they do. When the Department of Justice doesn't intervene, the success rate sort of is inverted. 90+% of cases do not succeed, do not end with a successful resolution. So that's the sort of nub of it. So from my perspective, what we're always looking for is to, persuade and to, for the Department of Justice to ultimately join the case.
We have a couple of questions from listeners I want to try to get to in the last 10 minutes or so here. And this is one that, Lisa, this might be more suited to you. You kind of touched on this earlier, but they were writing in saying, what type of internally produced documentation can support an organization's defense? They were specifically saying something along the lines of a checklist confirming that a DEI program is not illegal. I don't know if such a checklist exists right now for something that is so novel, but if you have any thoughts on that or other sort of, is there a checklist that you could go through to have like a basic FCA defense or documentation or file? Like, what would you advise this person?
So especially on the DEI side, I mean, we're advising companies, given the emphasis of DEI, to do these internal privilege audits. And these audits have to, it depends on what your company wants to do. There are things that are black and white, and there are things a lot in the gray. And what constitutes illegal DEI is very, very broad at this point in time. It depends on kind of your interpretation and review of the Supreme Court precedent. And those laws have changed over time. So we advise that you do kind of the internal privilege audit, but that you do create some assessment by somebody, and it is generally the compliance officers or somebody in the business who can say, I've done the audits, I've done the review of policies, I've taken the steps that I'm supposed to take as a reasonable stakeholder in due diligence and conducted my evaluation of my policies and procedures as implemented. And I can sit here today and make a good faith determination and a statement that I believe we are in compliance with the laws. And that is a key determinative point, so that if and when the government comes to your door, you have a defense to say, I believed I was in compliance with the law. And that good faith belief is a very, very strong defense to a False Claims Act case. It's a defense to the ultimate legality of what you're doing under the FCA, but it's also a good defense to kind of push the government from investigating, because again, the investigation of a False Claims Act case and the defense of a False Claims Act investigation, that alone is extremely expensive. So I would document those conclusions.
And then again, to your point, like they're trying to assess, is there a true culture of compliance? And so when you can kind of show up with a full baked cake and say, this is all my documentation, and you can convey that good faith, attempt, to your point, I think that has a disproportional impact on what steps they're going to take,
Speaking of a culture of compliance, I wanted to ask if we could have some more color on how the Justice Department makes that assessment. My experience has always been thinking about the Foreign Corrupt Practices Act and the evaluation guidelines the Justice Department has published primarily for that, but it could be used really, I guess, in any context. But I know that the Health and Human Services Department, their Office of Inspector General, they published guidance last year about an effective compliance program. They specifically called out the chief compliance officer should not be the general counsel or report to the general counsel. Like, I don't know if either Lisa or Ari, if you have views on what a good culture of compliance is supposed to be, or how does the Justice Department make that assessment? Do they have a checklist or a formula? Like, what could you tell people?
I mean, I feel like there's a lot of guidance out there from the DOJ that and the OIG, what they're looking for is the effectiveness of your program and how do you convey that it's effective. And there's like things that are typical in every corporate integrity agreement, right? That you have policies and procedures, that you have adequate training, that it's routine, that you have whistleblower lines and ombudsman's offices so that the complaints are fully investigated by HR or compliance or legal, depending on the situation, that you continually monitor all of your practices and policies, especially the activities that are could potentially lead to kickbacks or other things like that that would violate the law, and that you then roll any findings of noncompliance back into new training. And so those are like the key elements of a good compliance program, and I think the OIG's mind at least. And if you can have reports that go to senior management, to the board, to the audit committees, that here's what we found, here's what we're doing, here's the investigations we undertook, here's the outside counsel we hired, here's the changes we've made, and here's what we think are our high-risk areas that we are continually monitoring. All of those things go into a presentation to the government to show that your compliance program is effective and that senior leadership is listening. And I agree, from DOJ's perspective, they do not want compliance reporting to legal. They want compliance reporting to the business so that the business is held accountable at the end of the day.
So,
Look, I might sound like an idiot here, so, buckle up, but it seems like this is kind of like pornography. Like, it when you see it, you know what I'm saying? And so you're kind of making an argument, right? Like, if you're going to get that outside scrutiny, there's some argumentation that you're presenting to them. There's some sort of set of evidence. And I kind of consistently think that, like, solve that under the reasonable person test, or solve that under the reasonable compliance officer test, or, falsify whether, the hypothesis that I have an effective program, try to falsify that hypothesis and see what those kinds of gaps are. I think if you're genuinely putting a good faith effort in building an effective compliance program, that's probably your best defense than trying to throw the football through all these like swinging tires of all this different guidance. I think it's a lot more kind of art than science to some degree. They're probably not coming in with a clipboard because everybody has policies. Everybody has a whistleblower hotline, right? It's how we're actually using these elements to drive the effectiveness forward.
Ari, what would you say? Including the perspective of things you've seen that are terrible, and they're going to get nailed on this. I mean, what's your take?
I mean, I think that from the perspective of designing a compliance program, the core thing, to put it into a, sort of pithy saying, which I think everybody repeats, is the Department of Justice is looking to differentiate paper-based compliance programs from ones that have, real life that exist in the organization on a day-to-day basis. So in addition to the aspects that, the core aspects that Lisa talked about, that Nick just touched on, there are two things that I think about in addition, or to amplify. One is consistent enforcement and showing that there is enforcement under the compliance policies. So disciplinary measures are applied. They're applied fairly, consistently across the organization to reinforce the consequences of non-compliance when it occurs, if and when it occurs. Now, it doesn't occur in every organization, so you may not have that record to point to, but that sure makes it seem like a more real thing than a stack of papers that says, here's our policy and how we reevaluate it, in the fourth quarter of every year. The other piece of it is, how do you embed it in the daily operations of the business? And, partly it's sort of ensuring that compliance isn't treated as a sort of simple standalone function, but is integrated into the whole sort of range of business practices, operations, financial reporting, procurement, whatever the details of the business may be, the guts of it may be, compliance is a feature of each of those.
Like we always say, are we apart from the business, or are we a part of the business? Are we actually, are we like just a bumper sticker on the car, or are we actually helping that car drive down the road more, safely, or whatever? Sorry,
I
go ahead,
wanted to
Matt.
sneak in one last question here from a listener. Do you have any advice about how to handle complaints that might be filed with malicious intent, such as by competitors, and what safeguards are in place to protect against reputation or contract harm? I have to admit, I'd never stopped to think that that's something that happens. Whoever did this, you've now tarnished my faith in the goodness of humanity, but I don't know if it does happen.
Welcome to business, Matt.
But maybe I'll put it to Lisa first, and Ari, if you have any thoughts too. I probably only about a minute or so per answer, but do you have any advice on, is this a thing, or how would you counsel people?
I can only think of one situation where one pharmaceutical company complained to another pharmaceutical company about what they thought was misconduct. And company B responded in saying they would never do that. That would be illegal. And then they had those programs going on in their own company. So you have to just be very careful, but I guess would say, of how you respond to attacks by competitors, and fully investigate and keep it under privilege. That's what I would suggest.
Yeah. From my perspective, the Department of Justice doesn't discriminate based on who the whistleblower is, based on the identity of the person bringing forward the allegations. I know the case that Lisa is talking about, the case had a 9-figure recovery. I believe close to $500 million, if I'm remembering correctly. So it was brought by a competitor, but the case had legs, as they say. So that's one thing. The other is, you don't see it very often, but where we see it most frequently is in the custom space, actually, where competitors have reason to know, based on former employee relationships, that another importer with whom they compete is underpricing them and doing so by evading duties. So it certainly happens. The Department of Justice doesn't look at it any differently than if it were brought by, an individual employee.
All right. Well, we will have to close there. For the record, the Justice Department and HHS just yesterday announced a new False Claims Act Enforcement Task Group. I just popped the URL for that press release in the attendee chat for anybody. But Ari Emplowski and Lisa Dykstra, both of you gave us a ton to think about here, covered a lot of ground. We really appreciate your time. Thank you very much. And Nick, I'll let you take it home.
Yeah, I mean, this conversation was phenomenal. I love the Ethicsverse because I learn so much on it every time. We just broke 5,000 emojis. I love it. Let's try to get to 6 as we wrap up. Thank you so much, Lisa and Ari. This was really great. Matt, as usual, there's, it's well earned. I've been saying this for a long time, but you maintain that title the coolest guy in compliance. So thank you so much. Next week, we got 2 phenomenal episodes. We got the Ethicsverse healthcare episode on Tuesday. So hopefully you're not too hungover and sunburnt. We're going to be talking about open payments data with Mr. Martin. And then on Thursday, we're going to do a Compliance Week prep session. What are some cost-effective ethics engagements with the one and only Cara Novelli? So mark your calendars, show up, get some books, meet some new friends, and don't forget your sunscreen this weekend. See you guys next week.